Welcome to Discovering the Law. My name is Lucy Rivera and I am the host of this program. This episode can be viewed at www.discoveringthelaw.com. Today we have a very special guest because we have a justice from the Massachusetts Appeals Court, Judge Mark Green. Hello, Judge Green.
Hello, Lucy.
Thank you for joining us today.
I'm delighted to be here. Thank you.
Tell us about the Appeals Court, please.
Well, the Appeals Court is the intermediate appellate court in Massachusetts. It's in between the Supreme Judicial Court, which is our highest court, and the trial court, which is where all cases begin. Mm-hmm. There are 25 judges on the Appeals Court. That is an expansion from 2001. Before that, there were 14 judges. The Appeals Court was established in 1972, and it was initially established with only 6 judges. Mm-hmm. It has expanded a couple of times since then, and we just celebrated our 40th anniversary as a court, and we handle roughly 1,600 appeals a year. We start with all of the appeals from all of the cases that are decided in the trial court, whether they are from the probate and family court, the juvenile court, the housing court, the land court, the superior court, the municipal court, or the district court. They all come to us first, and then we take a look at them, and then the Supreme Judicial Court will take some cases after we decide them. They take some cases directly from us. They handle roughly 210 or 220 cases a year.
Oh, so that sounds 1,600 cases out of the whole Massachusetts state. Is that more or less like every year is like that? Did you see some variation?
There's variation year to year.
Right.
We will go through periods where we'll see an increase in appeals, sometimes because of a development in the criminal law. Mm-hmm. There'll be a new doctrine that develops, and we have to resolve a number of new appeals on issues that didn't used to arise. Sometimes there will be a change in the economy that will cause an increase in litigation of a particular type. Mm-hmm. The foreclosure area is one example of that right now. Right. We're seeing a lot of appeals from foreclosure cases. But with some slight variation, we will see somewhere between 1,400 and 1,600, 1,700 cases a year. We have maybe 2,200 cases that are initiated in the appeals court, but over time, some of those will be dismissed before we ever hear them. The parties work out an agreement to settle the case. Sometimes they are cases that are not ready for appeal because there was no final judgment in the trial court. But we wind up usually with around 1,600 cases a year.
That's an incredible amount. So how is the court organized to address this volume?
We sit in what is really an academic year. We begin our court year in September, and we hear cases each month until June. We do not hear cases, we don't schedule cases for argument in July or August. We use that time to catch up on the writing backlog. Each month we are divided into panels. The 25 of us are divided into panels of 3 judges, and we have one judge who serves as the single justice. Mm-hmm. The 3 judge panels will hear appeals from final judgments from the trial court, and the single justice handles cases that are in need of attention for a question that arose during the case of a pending trial. For example, there could be a preliminary injunction that somebody wants to challenge, and they want to get the single justice to review that. Or they claim that the judge in the trial has made a mistake on excluding certain evidence or allowing other evidence in, and they want to get that reviewed right away. Mm-hmm. Most of our work, though, is work on what we call panel cases, appeals from final judgments. A panel of 3 judges will sit ordinarily for 2 days of argument, and those are really 2 mornings. We begin our argument session at 9:30 and go till about 1 o'clock. We'll hear 6 or 7 cases on a hearing list. Each of those cases has 15 minutes per side, and with 2 argument days, we will have 12 cases that are argued, and we receive another 12 cases that have been screened and thought that not to require argument. So we have a total for a panel of 24 cases a month, If you're doing the math, you realize that 24 divides easily by 3. So each of us is assigned to write opinions in 8 of those cases, and then we review and participate in the decision on the other 16.
So 8 cases, you're responsible for 8 cases that come in to write.
To write.
And so that means that you're responsible for the decision?
Yes.
And what's the time from hearing to when you issue your decision?
On average, the court as a whole will issue our decisions in an average of 79 days as the end of last fiscal year. It varies from case to case. Some cases come out sooner than that. Some cases take a little longer. We all try to get our decisions written as quickly as we can because it's a little bit like a conveyor belt. I don't know if you remember the classic episode of I Love Lucy where she and Ethel are in the chocolate factory. If we're not careful, it's very easy to fall behind, and then it's very, very hard to get caught up. And we know that the parties are waiting anxiously for a decision in their case as well.
So Judge Green, do you get assigned to a panel that you decide of your colleagues, or is there a criteria as to what panel decides what, or the themes of the different panels?
Well, by statute, we are required to vary the panels from month to month. And so the panels are assigned at random. Our court administrator uses a computer algorithm to shuffle the panels, and we don't know from one month to the next who our panel is going to be. We actually know. I know, for example, right now what my schedule will be and who my panel will be in December and also in January. But that I don't know who my panel will be in February or March. The statute requires it. We also feel very strongly that we don't want to just have people choose who they get along with. We really benefit from the diversity of perspective, the diversity of background, the diversity of expertise and skills that comes with putting everybody together. And in answer to your other question, the cases are assigned at random as well. Now, the cases are assigned to the panel at random. The panel chief is designated either as the Chief Justice, if he's on the panel, or as the judge with the most seniority among the 3 judges. And the panel chief will assign the cases to particular judges on the panel to write. We try to do that with a presumptive order of assignment each month, and we shuffle that presumption from month to month so that the attorneys who argue in front of us don't develop any expectations about which judge is going to be writing their case and try to tailor their argument to that judge. But we will vary from that presumption from time to time as well, because sometimes a judge will have invested a great deal of effort preparing for that case ahead of time, or taken a particular interest in it and really want to write that case. Sometimes we'll have a judge that has a particular subject matter expertise, and it's a complicated case in that subject matter area. I had a specialty in the real estate area before I went to the appeals court. I was on the land court for 4.5 years as a trial judge. And so occasionally I will wind up with a case that involves zoning or foreclosure law or property law. I try to avoid taking on cases just because they're my specialty, because we all also try to expand our knowledge and to operate in all areas. And I think it's better institutionally and better for my colleagues, better for me, if I try to branch out and serve as a consultant rather than as the author on all the real property cases. But occasionally we will vary the assignments to take advantage of subject matter expertise.
So the jurists that sit on the appeals court basically have to be knowledgeable of all laws, and
we try.
What I imagine is, at one given day, you get appeals from all these different courts that you mentioned, or is there a day specific targeted to criminal?
No.
And then,
no, they are random, and it really the assignments depend more on the availability of the attorneys to appear for argument, and we also have another factor that goes into the scheduling is driven by personal affiliations that some of the judges will have we all are bound by ethical rules not to participate in cases where we may have some personal connection to the case, whether it's to one of the parties, one of the attorneys. My wife is a partner at a Boston law firm, and I cannot hear any cases, not just that she argues, but that anyone in her firm argues. So we all have a series of recusals, and so we schedule the cases based on availability of the attorneys and also availability of the judges to hear those cases based on recusals. For the argued lists, we do schedule 3 cases that are criminal and 3 cases that are civil.
Okay.
And so out of those 12 argued cases a month, the panel will hear 6 criminal cases and 6 civil cases.
And is there a way that the attorneys that are going to argue before the panel, a given panel, know who the judge who's writing the decision is?
Not beforehand. We want it to be that way because we don't want them to come in and be making eye contact only with one of the panel members like the other 2 aren't even there. Occasionally in the past, I've had the experience, again, going back to my real estate background, where we're hearing a case in zoning and the attorney will be speaking only to me, and one of my colleagues in the other chair will say, Mr. Smith, you remember that I'm here too, right? And so I think it's important for the attorneys to focus on the entire panel, and after all, we are deciding the cases based on a panel of 3.
Right.
The panel is 3 judges, not just because that's what most intermediate appellate courts do, but also because 3 is an odd number, and it means that if we have a disagreement, we can resolve the disagreement by majority vote.
I do want to ask you about the decision process, but before I would like to ask you, do the 8 panels sit at the same time, or is there some that take a break and there's just one panel at a given day? One given day, you can expect all of them at the same time? Or?
No, we don't have room enough for all
Right.
8 panels to be sitting at the same time. We have 2 courtrooms, and so we space our sittings. And that's what I mentioned before about the scheduling availability of the attorneys. If an attorney has a pending trial in another matter, they may not be available during the first week of the month, but they'll be available during the second week of the month. By and large, with 8 panels, and we don't do 8 panels every month because of sometimes we have illnesses or some other reason why we can't have a full panel. But usually we have 7 or 8 panels each month, and with 2 days of argument for each panel. That translates into 14 or 16 days of argument. If there are 5 days, when we can schedule those in a week, that gives us 10 courtroom availability days in each of 2 weeks. So we could in theory schedule 20 days of argument. That would occupy 8 panels for 2 days of argument each. Sometimes we will extend into a 3rd week for a couple of days. And recently, we have configured some panels with 3 days of argument. My panel this month, for example, had 3 days of argument and no list of non-argued cases. So it was an extra day of sitting, but an extra day of hearings. 18 cases for that month instead of the usual 24.
So you sat for 3 days, and next week you'll sit for 2 days?
Next month I'm on a conventional panel where I sit on the 3rd of December and the 10th of December, and we will also have a non-argument list.
Okay, we'll put our name there to appear before you on those dates.
It's an open, it's a public forum. You can, anyone is welcome to come into the courtroom and watch.
What is the process of the decision making when you're in the panel? You're listening at the attorneys.
Well, when we're listening to the attorneys, we're still making up our mind. We're asking a lot of questions. We've read the briefs. Maybe I should talk a little bit about what happens before we get to the hearing, because there's a lot of work that happens with everyone before we get to the hearing.
Yes.
The attorneys have filed briefs. They call them briefs. They're allowed to be up to 50 pages. Which is not so brief.
That's very brief.
But they describe what the case is about, what the facts are, and what the issue is that they are claiming is a reason for a change on appeal. We don't take any new evidence. We don't have any witnesses. We are simply reviewing the case as it was presented to the trial court, and trying to decide whether there was something that went wrong at the trial, either an error of law, an incorrect interpretation of a statute, improper or incorrect instruction to the jury about what the law requires, the admission or exclusion of evidence that either should have been let in or shouldn't have been kept out, and by and large, that's the stuff that's presented to us for a reason why the case should have come out the other way, or it should be sent back for another trial. By the time we get to the hearing, we have read the briefs, we have a transcript, we have all of the exhibits, we have the record appendix is what they call it, which contains the transcript and all of the exhibits and any other documents that were submitted in the trial court, the complaint, any of the other pleadings, any of the other arguments that were made in the trial court.
Okay.
And so we'll go into the hearing with a pretty good idea about what the argument is about, what the case was about at the trial level, and what we think of the arguments that the appellant, the appealing party, is making on appeal. We usually have in mind a series of questions that we want to explore with the attorneys, and it's really much more like a conversation than a presentation. At times, some courts have developed a reputation for being what they call a cold bench, meaning that they don't ask a lot of questions. But the appeals court, throughout the time that I have been there, and it doesn't matter which panel you have, we tend to be a fairly hot bench. We ask a lot of questions, and we really use the argument time as a time to go beyond what the parties have told us in their briefs. I have a personal rule. I tend to ask a lot of questions, but I know that the attorneys are not in the courtroom as often as I am, and I can walk into the courtroom and not have any particular excitement or butterflies. It's where I go to work all the time. But for most of the attorneys, it's a heightened sense when they walk in. You've been there. Yes. Maybe a little nervousness, a little butterfly in your stomach, and so I want to give the attorneys an opportunity to sort of get a little bit of momentum going in their presentation before I start interrupting them with questions. My personal rule is that I wait at least a minute and a half before I ask my first question. Thank you. And I know a minute and a half doesn't seem like that long, but really it is. We already know what you were going to tell us in your brief, and if you're just telling us that again, then we're really not learning anything. It's time to move beyond that and see where we can go. So what is the key? If you have our argument on the brief, what can we say that will be persuasive, or is mostly a question that you want to get answered when it's not clear? Well, it's hard to give an answer to that as a general abstract matter. I guess if I were going to give advice to someone like you, who's going to be arguing cases in the appeals court, I would suggest first to imagine yourself sitting in my shoes, sitting in my chair, wearing my shoes, and thinking, what would persuade me that something went wrong? It's not just that there was a mistake, but it was a mistake that made a difference in the outcome of the case. Yes. And we need to change something on appeal in order to avoid an injustice. Yes. So I think you start by seeing the case from the side of a neutral decision maker. Okay. I guess the other thing I would suggest is be prepared. Know your record extremely well. We are going to know your arguments. We're going to know the law, but no one is going to know your case as well as you do. And if you can direct us to the parts of the factual record that support the argument that you're making, that's going to be very powerful and very helpful to us. The third thing I would suggest when you're there at the podium making your argument is to listen to the question, answer the question. Don't try to avoid the question. If we're asking a question, it's because we're troubled by something, and sometimes the answer that you have to give may not seem like it's going to help you very much, but you still have to answer the question. And usually, though, when you get a question, it gives you some idea of what's on our minds, and you can use that information to tell you where that silver bullet is. Where is the place that you can really emphasize in your argument to put our questions, our concerns at ease?
Thank you. This is very, very illuminating. What about published decisions?
Well, you're referring to the fact that we don't publish the decisions that we write in every case.
Yes.
The difference between published and unpublished decisions is really twofold, maybe threefold. The published decisions are literally published. They come out in the bound green volumes that become precedent. They become binding precedent. We operate on the principles, as I'm sure your viewers know, of stare decisis, which means that we decide a new case that raises the same question in the same way that a previous case decided the same question. And so our published decisions are binding precedent for purposes of stare decisis. The unpublished decisions are simply persuasive authority. They don't bind future decision makers. And the reason that we publish some and we don't publish others is that many of the cases that we hear on appeal raise no new question. They are easily resolved by application of well-settled law, and there's no reason to say the same thing all over again. If we did publish all of those decisions, the green volumes would become overwhelming, and trying to find the decisions that actually say something new would be like looking for a needle in a haystack. The number of published decisions will vary from time to time. Ordinarily and historically, we tended to publish somewhere around 20 to 25% of all of our decisions. For some reason, the past couple of years, that percentage has dipped down to something more between 10 to 15% of our total decisions. This year, already, it looks like we're going to be back up at a higher level. I've seen more cases that I'm assigned to write already in the first 3 months of this term than I had for all of last year. So if that trend continues, we will be, and if it applies to all of my colleagues, we'll be back up to a much higher rate of publication. The other thing I should say about published decisions is that institutionally, we are firmly committed to the idea that our published decisions should reflect the view of the full court, so that even though a panel of 3 judges hears the case and participates in the decision, if any decision is going to be published, we circulate the draft to all 25 judges on the court, and we get comments back. Sometimes those comments are, I agree with this, but there's a case that I know about that would be very good authority that you should think about including. I agree with the outcome, but I think that the way you've said something on page 7 is not quite right. Here's what I suggest you say. Sometimes the comments are, how could you possibly think that? I think you're wrong. Here's why. And then we get back together and we talk to each other to see how we can address that concern. We don't always agree among all 25 of us. We don't always agree even among the 3 judges on the panel, but we do try to take the comments and critiques quite seriously and produce the best product that we can. And the idea of circulating to all 25 judges allows us to say that our published opinions really do reflect the view and the comment and the decision of the full court.
Your Honor, this has been a very meaningful conversation for us to understand and know how to practice in appeals court, but we've run out of time.
Really?
And we would like to thank you for coming here today.
Well, it's been my pleasure. The time has flown by.
And to all our viewers, thank you for your time. This is Justice Mark Green from the Appeals Court of Massachusetts. And you can view this interview at www.discoveringthelaw.com at any time. And thank you for watching. My name is Lucy Rivera.